Hello, everyone. Thank you for taking the time to watch this presentation. In this presentation, I will be discussing the topic of social media as it applies to schools and school law. As you are well aware, we are in the digital age. As teachers and students, that has implications for us. The use of social media has increased significantly over the past 2 decades. Thus, social media has blurred the line between school and personal life. Consequently, schools must balance maintaining professionalism, protecting free expression, ensuring the safety and the order of the school. Most of the school practices are guided by federal case law, state regulations, local regulations, and their district policies, which normally adhere to the federal case law and regulations established by state and local. Most of the federal case law and regulations at the state and local level are a result of the First Amendment and the free speech protections that the First Amendment has for teachers and students. Evidently, teachers and students have certain free speech protections. But speech could be limited when it disrupts the educational environment or interferes with the rights of others. Therefore, the case law helps define the boundaries of protected speech. So, what is protected versus what is not protected? Let's begin by discussing teachers and social media. There is federal case law, state and local regulations that apply to teachers. Districts enforce codes of conduct to maintain professional standards. Most, if not all, of these codes of conduct adhere to the federal case law, state and local regulations. Online posts may result in disciplinary action, including termination. It is important to note that private or personal accounts are not exempt from scrutiny in the eyes of districts or at the court level. One of the first case laws is Pickering versus the Board of Education in 1968. In this case, a teacher wrote a letter to a local newspaper criticizing the school board's handling of funds. The issue was whether the teacher could be fired for speaking on a matter of public concern. The Supreme Court ruled that the teacher's speech was protected under the First Amendment. The key principle that was established was that public employees can speak on matters of public concern unless it substantially disrupts the workplace or impairs the school's operations. The next case, which not directly applying to schools and teachers, but still a public employee, Garcetti versus Ceballos in 2006. In this case, while performing his official duties, public prosecutor Richard Ceballos authored a memo criticizing alleged government misconduct. The issue: does the First Amendment protect a public employee from discipline for speech made pursuant to their official duties? If I can back up, In this case, Richard Ceballos authored the memo while he was on the job. It's important to note that he made this while he was on the job. Therefore, the Supreme Court ruled that speech made as part of official job duties is not protected under the First Amendment. This established a key principle that public employees speaking pursuant to their professional responsibilities can be disciplined without violating free speech rights. As an example, a principal giving a professional development. In that professional development training, he negatively talks about the school district superintendent. In this case, this is where the Garcetti v. Ceballos case can apply, because while he is speaking as part of his professional responsibilities, he made negative comments about the superintendent, which affects the school. Moving on to students and social media. Students have free speech rights, but these are not absolute. There is a key distinction between on-campus versus off-campus speech. Schools may intervene when online activity constitutes bullying or harassment, poses safety threats, causes substantial disruption to the school day. Any one of those may allow the school to intervene with the online activity. These were established by the following case laws. First, Tinker versus Des Moines in 1969. The incident was that students wore black armbands to protest the Vietnam War. The school's response? They suspended the students for violating its policy. The Supreme Court ruled that students do not lose their First Amendment rights at the school door. The key principle that was established was that student speech is protected unless it causes substantial disruption to the educational environment. This has had a long-lasting effect and legacy, and established the standard still used today to evaluate student expression in schools. Mahoney versus Bial, 2021. The case. A high school student posted a Snapchat criticizing the school and cheerleading program off campus. The school suspended the student from the cheerleading team. In this ruling, the Supreme Court ruled that off-campus student speech is generally protected by the First Amendment. But the key principle outlined, schools may only regulate off-campus speech in limited circumstances, such as when it harasses or threatens others or causes substantial disruption at school. This case was the case that reinforced the distinction between on-campus and off-campus student expression. The third case, back to 1968, Bethel versus Frazier. In this case, a high school student gave a speech full of sexual innuendo at a school assembly. The school decided to discipline the student for using the lewd and offensive language. In this court ruling, the Supreme Court ruled that schools may prohibit vulgar, lewd, or offensive speech in the school setting. The key principle that was established was that schools can regulate student speech that is inconsistent with the school's basic educational mission, even if it does not cause a substantial disruption. This case is slightly different from the previous case, Mahoney versus BL. In this case, the student did make lewd and offensive behavior, but the Supreme Court allowed it. However, in the Bethel versus Frazier, a student made lewd and offensive language and did not allow it. So just showing the two different sides. One of the big things for off-campus social media posts is this 3-part nexus test. It's frequently used by school districts to guide discipline for off-campus social media posts. Question number 1, does the post target the school community? If so, does it cause or predictably cause substantial disruption? And then lastly, does it infringe on the safety/rights of others? In this case, if it was a yes to all 3 of those questions, then the principal administration can decide to discipline the off-campus social media posts. However, it is important to note that as an administrator, it would probably be in your best interest to discuss this with the school's attorney. One thing that came up in my research was students' social media privacy. What can and cannot, what can a school monitor and address in student social media? First thing to note is schools cannot compel students to provide social media accounts to them. This includes their passwords. There are state-specific laws. For example, here in Illinois, in 2015, there was a law passed, the Right to Privacy in the School Setting Act, that restricted school access to student social media. There is a big trend on monitoring versus access for schools. Schools may monitor public online activity, but forced account access is widely prohibited. A few key takeaways. Teacher professionalism online, so through social media. Professional standards and conduct extend to all digital platforms impacting employment, such as social media. Student speech rights. Student free speech is protected but balanced against potential disruption and safety concerns. The role of policy and law. Laws and policies are crucial in defining the boundaries of online expression. And there is a balancing act. There is an inherent tension that exists between individuals' expression and the school's authority to maintain order. I hope this presentation was satisfactory to you. If you could, in the discussion board, I'm going to post a question to continue the conversation on what can a school monitor in terms of teachers and students' social media usage. Thank you. Have a great day.